Again, just wanted to say thanks, Jeff, for jumping on with us. Super excited to have you, and I'm sure a lot of the listeners are going to be super excited to hear what you have to say. Not just because they're just starting, but legal stuff is important, right? Everybody that's listening to this, they're either a new founder, a new entrepreneur, or maybe they're more established and have some of those harder questions in terms of partnerships, entity structures, different things like that.
Yeah.
But before we really dive into that stuff, tell us a little bit about you, about what you practice, and what made you want to become a lawyer of all things.
Yeah, tell us about the pathway, because I think it's pretty interesting.
How long do you say we have? An hour and a half? No, I always knew I liked the engineering side of things from high school. And then I knew I wanted to go to business school. But long story short, all of those top schools I applied to with absolutely no work experience told me probably what they should tell me and said, no, you need to go get work experience before you reapply to our business programs, their MBA programs after engineering. And that was my plan. I didn't get back to the MBA path until about 5 years ago. And in the meantime, I got diverted on this long path through law school when a buddy said, you should go get your law degree and become a patent attorney. And I'm like, that sounds awesome. What is it? I had no idea.
Friend, right? You just did it.
Hey, he sent me down a good path. I'm not complaining. So, and I love practicing law to this day. Although I wouldn't do it if I were, in a different field like family law or something. Just not my cup of tea. So I went through law school, both engineering and law school at the University of Utah. Moved out eventually to California. Worked in the Bay Area for a couple of years at what's called a patent boutique firm, focused almost exclusively on helping people get patents. We didn't do much enforcement. It was all about, you have an invention, we'll file a patent application, we'll process that or prosecute it is what we call with the patent office back and forth, and did that for a few years. The entrepreneurial bug in me got me away from that, and I started my own practice, went there, and I did that for about 8 years, moving back to Utah, joining up with a couple partners out of Silicon Valley. And then that's when I thought I need to follow this business path, or at least supplement everything I've done with more business experience. So I went and applied for BYU's executive MBA program, started that, decided to make my practice more general so that it wasn't just talking patents and technology and engineering the whole time. I wanted to be more involved in the business overall. So I went and I moved my practice down to a general practice law firm with the idea of getting involved in some general practice, some more corporate business type client matters. The goal was to get in-house in 5 years. In-house being I work for a corporation, right? I'm on the executive team or whatever it is. And that happened, but it was 5 months, not 5 years. So,
oh, geez,
someone called me and said, yeah, you're my plan, but like, not yet. I just barely moved my practice here, like not yet. But through a series of conversations, I ended up, linking up with them, going through the process, accepting an offer. And I worked for a company called HCO, was their general counsel for a while. They're still a client of mine, but they moved out to North Carolina. And I stayed here in Utah. I loved working with them. I learned a ton of stuff that I didn't know beforehand. That's what being in-house counsel does to you.
Yep.
Just like a startup, right? You get involved. You're like, I know how to build this, app, or I know how to, go raise money. You don't know the dozen other things that you didn't realize you didn't know until you tried to do it. So it was a great experience. But when they moved out, I was actually really excited to take kind of the engineering, the legal, the business, wrap it all together and kind of fire up my law practice again. So that's what I've been doing since then. And it's been a blast just building something that I feel like is valuable beyond just, oh, you've got an invention, I'll get you a patent. That didn't feel like it was contributing either to society as a whole lot, or to the business value a lot either. Patents are worth a lot in some cases and not in others, but how does that fit into the overall picture? It's just one piece. And I wanted to be in the overall picture, helping guide, make decisions, figure out strategies, avoid major business risks, all that stuff. So that's a short version.
Yeah. So would you say that your back, because that's what's so unique. And that's when we start talking to you, we realize that got us really excited because you have an electrical engineering degree.
Yep.
You have a master's in business and you have a law degree. So in reality, you can come at these entrepreneurs and kind of give them multiple angles on their ideas or their businesses. Correct?
Yeah. I think that's a fair statement. And I mentioned before to you guys that I think part of what I do is I'm just an interpreter or a translator. When I'm talking to a technology team, I talk more technology, more engineering. When I'm with the business guys, I'm talking more about, and what it is really is talking engineering and legal concepts in business language, or, vice versa, translating why is that business concept important when we're trying to get a patent, or, all those things. So really going between and trying to unify the conversation among the team members. And as legal counsel, you're in a really interesting position in my perspective. You have a little bit of leeway, freedom in a company to step into roles where other people maybe can't do that or don't feel comfortable doing that. We're always identifying issues, trying to minimize risks. And so when we see something, we'll often say, is anybody doing this? No. Okay, let me figure out what that pathway is so that somebody else can do it, or so that I can plug that hole in the meantime. So like at HZO, we had transition in management, like some, startups have at different phases in their growth. And I said, we've got some team things that we could improve, but our HR had transitioned out. We didn't really have that. I'm not an HR guy. My background's engineering. Some people would suspect that I'd rather not talk to people at all than, help figure out HR issues. But when there was an opportunity to bring the team together, I said, well, why don't I figure out what team members should come into this kind of all hands meeting? And it was funny because I said, no, CEO, you're not invited. No, I can be there. I'm like, nope, you're not invited. I think we're going to do it at this level. And then I'll come and I'll be the connection between this level of the discussion and the executive level, because that helped facilitate some things that wouldn't have happened the same otherwise. So
yeah, it sounds like you've kind of just been everywhere in terms of that ladder of growth. You've been a part of so much. But I mean, like, how many different startups or different groups have you been a part of?
Oh gosh, directly, I've actually joined the team or been even an equity position in a handful, probably 6 or 8 is all. Some of those.
How many of them were software?
So most of them include an aspect of software. There's probably 1 or 2 that are just strictly software. And then the majority of them are some type of hardware and software together. And then a couple of them have nothing to do with software at all. They're just hard goods. So
got it. So the ones that were, let's say, software startups, which ones did you find did really well, and why, versus, which ones didn't and started to, slow down or go away?
So is this the magic? This is the time where I tell you the magic formula, right?
Yeah.
Well, exactly.
Because our listeners haven't subscribed yet. If they have, then yes, we can continue on now.
Yeah. So write this down because it will always work. No. No, it's probably going to be a combination of the same stuff that people already know about. I think it's the NPR How I Built This podcast, and he always asks at the end, how much of what you did was based on luck and how much of it was your hard work? And I think that luck and timing plays a really important role, whether it's building your team, hitting the market, even guessing what the product is for the market you're trying to hit. I mean, you've got so many variables you're trying to align all up front in that MVP stage or lean startup mode or whatever you want to call it. You're trying to line all of it up at once. That's tough. And so luck is a big issue, but more so than that, you gotta persevere in that. You don't find luck without perseverance. And then I think the one that you have a little bit more control over is funding. You really have to get funding to grow. It's super hard. In fact, from a law firm perspective, you don't hear of lawyers going out and getting investors for a couple different reasons. Most of it's because we can't, the rules of ethics prevent us from profit sharing with people who aren't attorneys. And so it's hard to find an investor who wants to put money into a business like that. Plus, I'm not sure our multiples are right for investors, but funding is super important to give you the runway to experiment and figure out, do we have the right product for this market? And if we don't, I mean, you need more time, right? If you don't have the time, you might be on the right path, but if you don't have the time, you won't get far enough down that path. And funding is just
just buying that time that it's basically buying you time to fail, right? And pivot.
Yep. Exactly.
And I know we had kind of talked about market validation and market fit. Can you touch on that? Kind of what is so important and why investors are so focused on that?
Oh yeah, for sure. So if I could, let me step back just real briefly. I kind of, when I have conversations with people about their ideas, it used to be pretty one-dimensional. It was, oh, your idea, that is crazy. Don't do it. Right. That's what inventors do, right? Inventors come up with stuff that didn't exist before, and it all sounds crazy. And some of it legitimately is, and some of it we think it is because we don't know any better. So they come in with an idea, and now my conversation's a little bit more multidimensional. I'm like, well, I view it as three things you've got to do. One of those is you got to validate your market, right? That, like you mentioned. The other that you have to do is validate your technology. Can it actually work? Can you make it the way you want it? The way, can you afford to put all these pieces together? Just validate that you can get the technology up and running within your parameters. And then the third is what I call freedom to operate your business. Everything that you need to put in place so that you can protect your ability to run your business. Some of that's just the normal, administrative, financial accounting type stuff. You've got to have that. You got to put an entity in place at some point. For me, a lot of it focuses on, are my patents and trademarks, my branding, my technology, are those the strategic assets that I want them to be that protect my competitive advantage? So I kind of view those three lenses first: technology validation, market validation, and freedom to operate your business. To your question on market validation, I mean, every investor is putting money into this. And I haven't met any investors yet that think money is something that they should just be giving away or not treat lightly, right? They're in this because
money, right?
Yeah, I mean, they some people don't value money as much as investors do, but every investor I've ever met, they value the money side of it, whether that's to have it so they can give it away and make an impact, or to have it so they can grow it into more. And market validation is the only one of those three that really tells you if you can make money in your business. You can have all the technology you want. You can make sure it works. You can build the coolest project. And that's what people do. We hear all the time, don't put all the features into your MVP. You have to build the right size technology for the market and what they're willing to pay. And the freedom to operate. I mean, nobody wants to build a business just to have a finance team, an HR team, and a lawyer employed. Like that would not be a very fun team to be on, perhaps, most days. And so it's really about market validation. Are you validating the market for what you're trying to build? And those three probably have to come up and grow or build commensurate with each other. But the one that matters to investors is market validation. And that's either users or profit or revenues or some metric that tells them, yeah, I've seen this before. This will become money at some point, a return on the money I put in.
Austin, you got a really big smile when he said, "Don't put all the features in an MVP." How many times have you said that?
It's literally like every single one of our conversation that comes up, and everybody. I mean, it's great. Like, in part of the initial portion of the idea, like, we love hearing about it. Spill your dreams, tell us your goals, tell us what you want to have implemented. But at some point, you kind of got to step back, see what the users really need, and go from there. Really, the number one question that comes up in every conversation is, what do you guys need yesterday? Like, what do we need to get to market super fast? And what bells and whistles can we skip on? And it's just super funny, especially in like this funding stage. Like a lot of people, especially I see it more in like Utah, more and more Utah VCs, I feel like, want that traction before they make that investment. And, there's no point in dumping, hundreds of thousands of dollars on the complete thing when you haven't validated the idea. So everybody really just needs to start simple and then move on from there. But what's super funny with that is before every single I would say 50% of our conversations, I get asked, hey, will you sign this NDA before you chat with me? And my usual response is like, no, I don't want to sign an NDA. Like, you can tell me your idea, I'm not going to steal it. But from a legal perspective, how often are you encouraging these new people, these new software ideas to really encourage and push an NDA? And when would the right time be to have somebody sign an NDA versus, I would assume, majority of the cases being the wrong time?
Yeah, that's a great question. And as kind of a general rule of thumb, we know that a lot of people, many investors won't sign an NDA. They'll just tell you no. So don't, people say don't ask. I think that the NDA question comes down to a couple of things. First of all, if you're not using the right NDA, getting people to sign the NDA, you might not even know what you're getting. You might not be getting what you think you're getting. First of all, that's very likely. And second of all, you might be incurring some risk on your end by entering you're entering into a contractual agreement through an NDA, and by getting this contract in place between you and somebody else, you might have risk that you didn't even know you did. So there is a risk to having an NDA signed unless you know what's in it. I've told people, if you really want to have one and you don't want to pay an attorney to do it and you want to go pull it off the internet, go ahead. Just understand, you're getting something that you probably don't realize. You probably understand, and this isn't to say that non-attorneys don't understand stuff, because there are a lot of really smart people out there who know this inside and out. A contract looks like it's written really clearly, but yet there are half a dozen gotchas in there. And you just wouldn't know it if you haven't either been sued on it before or gone to law school or seen it with other clients and stuff like that. So it just, you just wouldn't recognize it. So I would say if you don't know what's in your NDA, I wouldn't press so hard to use an NDA. So I'd get one vetted before using it. The other side of that is from a technology standpoint, and I might come back to another point on this related to what you said in just a minute, but from a technology standpoint, and specifically protecting your technology, if you have new technology that might be patentable, I think it's actually important to use an NDA, because if you have anything that's considered a disclosure, a public disclosure of that technology before it's patent pending, in the end, giving up rights to your ability, the right to even apply for patents on the technology. And patents in the software world, the app world, that's kind of its own hairy monster that's got a lot of difficulties with it already. But if you want to preserve the right, even the option, so that when you do have money coming in from an investor who's, keen on having patent protection or something, that you at least have the right to, the opportunity to go do it. And so an NDA helps preserve that opportunity for you.
From what I'm hearing, you probably recommend an NDA if basically had the opportunity to patent a specific piece of technology. Now, I would say 95% of the people we work with, what they're doing really isn't new or different than what's already out there. So when it comes to software, the harder question, I'm sure for you, or at least for you to answer, is how would you define, like technology that really like doesn't already exist? Is that just like a piece of hardware that like interacts with a piece of software? Because everybody is like, hey, let's build the next, DoorDash, let's build the next Uber. I would say another big thing is wholesaling has definitely become big, and there's a lot more software going around that. And everybody, wants these agreements signed. Is it as simple as saying, hey, this is a new flow that hasn't been done before, can we patent that? Or is that not the case?
Gosh, let me give my disclaimer, because you're asking a person who makes arguments and advocates on behalf of clients all the time that something is actually new and patentable, right? So that's what people pay me to do. That being said, there's some kind of simple rules generally for patents. It has to be novel, meaning that it's not identical to something else that's already out there. And a lot of software isn't identical, right? You're creating something that's sort of new. But then it has to also be non-obvious. That's the backwards way of saying it can't just be foreseeable change to something else that's already out there. That's got its own list of legal criteria and testing you can walk through. But in the end, in the software world, currently what you'll find is a lot of software is very difficult to get a patent on, because they either say that it's pretty obvious to do what you're doing. You're just rearranging the back end functions in a different user interface, perhaps. That's what happens a lot of times, right? You're not building a brand new way to store data. You're just accessing it and showing it to the user in different combinations. That in and of itself isn't necessarily patentable. The other thing that they say right now, and this is more applicable to software than anything else, is you're just taking a mental process and you're putting it into a computer, and you're not changing the computer. You're not creating new hardware. It's just you could do this on a piece of paper. Now, you and I know that nobody would ever be able to achieve on a piece of paper or a notepad or a library full of binders what computer does today in a fraction of a second on your phone, right? It's a fallacy that they put up to just reject your patent on software. But nevertheless, that's what they do. And they say, oh, you're just taking a mental process and you're putting it into a software, inside of a computer. So that's presented a really big hurdle for software. Where I get a little bit hesitant on this is that, one, I still see a ton of investors who come back and they say, if you're trying to get money, I need you to get patent pending. And so that almost ignores the discussion around, can I get a patent on this? And the investors want to see it patent pending. There's ins and outs about whether to do that, how much money to spend on it, how much effort to put into it. But it often becomes part of the discussion. The other thing is that software patents, and we're going really deep here on this, maybe too deep, but the rules and the laws around software patents 20 years ago, they were something totally different. Now we've swung clear over the other side. And the expectation is at some point it's going to swing back. We don't know how far, we don't know when. When it swings back, if everybody, in the software world has written off patents for the last 15 years, and that swings back and you've got a patent on something, is that going to be a huge competitive advantage for you in the future? I don't know. Maybe, right? There's just that, just another consideration. So
before I kind of move on too, I wanted to ask, I know that you had said something on the lines of like an NDA, but let's talk. I know a lot of our listeners are looking to build budget, right, as the cheapest option. So one of the cheaper options is offshore development or out of country, especially in this specific industry. They're looking for offshore and we hear a lot of horror stories, but let's talk a little bit about the legal sides of, are they held by the same laws, the NDAs, things like that?
Yeah, great question. I'll talk about a couple aspects on this briefly. One is, and I can relate this, it relates a little bit better to offshore manufacturing because there are some really clear differences there. But offshore development is going to have some similarities there. And that is contracts in the US, like your NDA will say, oh, this contract is governed by the laws of the state of Utah or Delaware or wherever, right? Mm-hmm. And you take that over to China or some other foreign country where the work is actually being performed by a team of developers, and you say, and something happens and you want to enforce your contract against them, a lot of countries will say, we don't enforce Utah laws here. Like, what are you going to do, right? And I know offshoring probably doesn't happen in China as much as it does some other areas in the software development world right now. But in China, if you get your product manufactured over there and you write your contract with Utah or any other U.S. state governing law, they'll immediately sign it. They'll be like, yeah, I'll sign whatever you want, because you will never, ever, ever be able to enforce that against them at all. And so it's not only is it not helpful to you, it's harmful because you have shown them that you don't understand how their industry works in their country. So I think you have to be careful for that reason. I think you want to know what you're getting into. In terms of NDAs, the same would apply for engagement letters or consulting agreements or whatever you want to call it, that, the contract that governs how you work together, how you pay, who's liable for things, all of that. The other thing that I think is going to become an issue, I don't know when, but I think it's going to become more of an issue sooner than later. And this is a parallel to what happened in the patent world. Back in 2003, 2004, I had friends saying, Jeff, why don't you send all your patents to India? Have them drafted, you can pay them $200 and you can charge your, $10,000 or whatever and get the, all the profit off that. I'm like, first of all, I've never heard of a story of sending it overseas where the quality came back worth more than $200. So no thanks. Yeah. Second of all, and I'm not saying there's a lot of smart people out there in different countries and software development, there's tons of options, right? But in
Yeah.
my experience, everyone I saw doing that just didn't get what they expected to get, and they stopped. But the other reason they stopped is because there's this thing called export controls. And I think that this is going to become a bigger topic. I know that large corporations talk about this in terms of their technology. Smaller developers probably aren't talking about this nearly as much or enough as they should. And that is the US and a lot of countries have laws that regulate what type of, they call it technical data, you can export out of the country. In the patent world, when you brought an invention to me and I said, well, maybe I'll have this drafted in India, what I was doing by turning around and sending the disclosure of that invention to somebody in India was I was exporting technology. I was exporting the technical data and possibly breaking laws, federal laws, if I did that, right? And so I don't remember what it was, 2005, 2006. The US Patent and Trademark Office actually put a button when you logged into their electronic system with your login and you're going to file a document. They actually made you click a button that said, I certify that I'm complying with US export laws. And so a lot of that offshoring dropped off then. Not all of it has. It should, but it hasn't. And I think in the software world, you guys are exporting technical data. If you send stuff overseas, and I'm not saying you shouldn't, but you should be aware that you're exporting technical data. And one of the funny things is exporting technical data might mean giving it to your teammate who sits next to you in a cubicle somewhere here in the United States. Because if those people are foreign nationals and don't have the right documentation, they have the documentation to work here in the US, but they don't have the documentation to qualify to receive technical data, you could be exporting by sending it across the table or shooting an email off to your teammate who doesn't qualify.
Who's not right. So basically, it's an option, but just be very, very careful.
I think you want to be careful. Yeah. And if you were to, one of the things a lot of people do is they'll kind of baseline their practices off of what might be considered industry best practices, and they'll look to the large corporations who have sophisticated teams and processes in place and say, what are they doing? If you talk to Microsoft, the way that they implement their cloud structure is going to be compliant with all of these export laws. That's why it costs more. It's more sophisticated. A lot of things are happening that you and I don't see, but they have to comply because, the government's looking over their shoulder. Maybe not our shoulders yet, but at some point they might.
That's super interesting. Just all the way, there's so many different angles that you're supposed to think about things, and you never do it, obviously, until you talk with somebody, right?
Yeah, and as an entrepreneur, it's hard because you don't have the resources to develop a Microsoft infrastructure. Like, it's just given.
Yep.
So, there's, I wouldn't say that you're never free of risk, but there's some point at which you got to hustle, and you got to get to the point where you're viable and hope you don't trip any meaningful legal wires along the way. So,
yeah,
definitely. So let's talk about, someone who is starting a company, right? They're just at the beginning stages. Legally, what should their steps be? When it comes with the budget, things like that.
Like, when is the right time to actually, go in and apply for your LLC and do everything and actually start to care about all the legal stuff?
Yeah, I'm an attorney, so it's yesterday. but no, I everything I'm saying, I understand that there's kind of the theory of it and the best practices, and then there's the practical application. Not every college startup is going to turn around and spend $15,000 or whatever to get everything lined up before they start, writing their code. Nor should they. But you should be early on thinking about all of these things and be aware of them. There's a good article. I should send it to you. Somebody circulated it recently. It has like a VC's perspective on the 15 legal things that you should be watching out for when you're starting your company. I'll try to find that and forward it to you guys later.
Yeah, I would love to share it.
But really, you should be thinking about a couple things. Your business entity, anytime you're going to start selling to clients, you should figure out what your business, you should get a business entity in place. It protects liability. What type of liability? I don't know. It depends on your business. But there's going to be liability with your business in some form. One of those first early types of liability might come in the way of user data and privacy policies, whether or not you have that stuff in place. So getting an end user license agreement or terms and conditions or privacy policy, those are all really important. And some of these become more important if you're going to release your product and accept subscribers out of Europe, and they're going to be coming out of Europe. You've got much higher privacy laws than if you're in the States. But if you're in the States and you're going to have people from California signing up, you've got high privacy. And there's a multitude of states now adopting these higher privacy thresholds. So that's important. A little less frequent. HIPAA is a big deal if you're going to have any healthcare data in there. I'm not going to go into that, but that becomes a trap for you if you do that. Or if you've got healthcare information you're passing back and forth, right? So your entity and kind of your user terms and conditions of privacy, I think, are all really early stage issues that you should be dealing with. They're not too expensive to deal with. There are different ways to do it. From an IP standpoint, which is what I focus on a lot, I think that if you've got something you think is patentable, you should protect the secrecy of that until you have a patent pending if you're going to go that path. If you're not going to go that path, you should think about trade secrets, which doesn't just mean you never tell anybody. It means that you have a little bit more formalized process internally to identify what your secrets are and identify how to control access to those secrets. Even if it's just writing a little policy that says these are the types of information that are confidential within our business because they add to the economic value of what we're doing, and here are the people or the types of people who should get access to these. And we implement that, just with permission controls on a server at a minimum or something, right? So patents are trade secrets and not telling people that. The other thing that you can do is you can, and this is the opposite of patents, for your brand, if you've got a good brand and you should probably do some research and figure out your likelihood of using that brand long-term is. But if you've got a good brand, you should start using that brand as early as possible. Opposite of patents and trade secrets where you keep that confidential as long as possible. Branding, you actually start to establish your rights by using your brand out there. So, throw up your webpage, put your brand on it, say something about what you're doing, but not your secrets, right?
Yeah, it's funny how there's two sides of that coin, right? Like, got to keep your secret, but you want everybody to know about you at the same time. It's kind of a hard coin to be on. So when it comes to like investors, and let's take a spin on investors side of it, what legally are they looking for when it comes to like patents? I know we want to talk about like minimal risk, and I don't mean to put you on a spot, but let's talk about maybe a company that an example of why it was higher risk and why investors wouldn't want to invest in that company.
Before I do that, let me jump back to the last topic real quick, and because it ties into investors, and that is getting your investment documentation in place early on is easier if you're doing it as you go than trying, all what we call due diligence or your data room sometimes where you put all the stuff. Do that as you're going. That would be another piece of advice I'd give early stage startups to do. I know it's the easiest thing to put off because there's no urgency around it, but just collect your information in an orderly way. You'll be good. To your question, Baudry, the things that investors are going to be looking for, I mean, it gets back to what we talked about earlier with market traction. Like the most important thing is to show that you've got, all the market metrics there. You've got a very large audience for a product that has good margins on it that you can make and you can scale it out to people, and that you're showing how you're getting traction in that market, or you're maybe not even traction, but you're at least validating those steps as you're building. That's always going to trump anything else that you're doing. Aside from that, though, you don't want to have this awesome product or opportunity for a business get tripped up by kind of the dumb little things. And those dumb little things are probably going to fall into the freedom to operate bucket that I mentioned before. Can you protect it with patents or trade secrets, or how are you going to protect it? What is the competitive advantage that you've actually got? And do you have something around that? And maybe it's layers. Maybe you can't, there's no, silver bullet to protect it with just one thing, but maybe you need to layer on things, different types of IP mechanisms to figure out how to protect that for people. Not having your business in order, your entity isn't correct, and you have to go maybe convert that from one form to another form, or not having early investor. If you took seed money or something and you don't have the documentation around that to show what that was and what those investors are entitled to, those types of things are more on what I call freedom to operate, and they're going to trip you up.
Never even thought are you talking about like angel investors? If like you promised angel investors something, you need to have some type of a documentation to present that to possible VCs as you're going forward. Is that what you're saying?
Yeah. I mean, if you're an investor, do you want to invest in something where there's this unknown financial obligation to somebody that you don't have any control over? Probably not, right? Mm-hmm. How much does that angel investor get? Was there something established, or is it, or did you just say, we'll figure out what your ownership is at some future point in time? Like, and that's not uncommon.
I was going to say, I feel like that's probably more common than we would like to admit to.
Well, and it's even acceptable if it's documented right? I mean, that's what a safe agreement is. It's very commonly used with early stage investors. You say, hey, put some money in, and you're going to get this multiple at some point in the future when we have another valuation event. And at that point in time, you'll know exactly what it is. And there's kind of some safeguards on to tell you that you're going to get at least this much, but they don't know what they're getting yet. And they're okay with that because it's written out in a document.
Is there a rule of thumb for that? Like, how much should people actually be giving away at each stage?
Yeah. So
question.
Yeah, it's a good question. I'm trying to tell you how what the answer is in a way that doesn't say there's not a good answer. But the answer that I would give you is there are with these early stage investments, a lot of people will kind of mimic what's happening on the broader scale. So if you look at some of the agreements put out by large law firms or by some of these accelerators like Y Combinator or Techstars, the things that they're using are going to be what people are usually familiar with or have noticed and will want to replicate. Again, these investors, they're not looking for risk. They're not looking for a way to lose money or give money away. They want to do something that's tried and tested. So they're going to say, well, how much are all these other people giving away in equity for this type of investment? If I put $150,000 in, what do I get for that? So they're going to mimic each other. So I would, instead of telling you what that should be, I would say, whenever you're listening to this podcast, go pull up that document. Those documents are available. They give them away, right? You can get a copy of the safe that people are using, see what the terms are, see if that's what has been used for a period of time. And if so, it's probably what you should mimic at that point in time. After that stage, it's more a matter of, is your business progressing along enough that you can justify not having any down rounds? The investors are going to look, they're going to say, well, why'd the valuation of your company go down from here? That hurt your prior investors, or it hurt me because I invested before. Why do I want to put more money in at this point? So after that initial kind of normal investment round, it's a business thing from there. Yeah. Not a very good answer, but
probably the best answer is stay organized and keep that documentation at all times. It sounds like it's super important to make sure that regardless of what you do, make sure it's documented one way or another. That's what investors are looking for.
Oh yeah, for sure. And take advantage of the tools that are available. Like, I love Carta. Carta is an online platform to help you manage exactly that, right? You can put all your documents in there. You can create a data room. Jeff Erickson here in town is a great resource for this. He works with them. Great guy. You should have him on your podcast, actually. And I'll connect you if you don't know him. But I've used this with some of the companies I've been at, and it tracks your cap table, which if you're not familiar with that, or if your audience hasn't heard of that, that means when investors put money in, how much do they own? And as more money comes in, all those ownership ratios kind of change, right? Okay. And you have to track that over time. Money comes in at different times when your business is worth different amounts of money. So it gets a little complicated. And then you're giving stock options out and other things that complicate it even more. So this is a tool that tracks all of that for you, does a fantastic job. And for a little plug, if you have raised less than $1 million, and I can't remember what the standard is right now, but have less than 25 investors, and might have moved it to 50, but around that zone, $1 million and 25 investors, you get a free account. And I would tell every one of my clients, like, sign up for it. If you're raising money, sign up for it, get on the account. If you end up not using it later on because of whatever reason, that probably means you're not doing very well. But if you're doing well enough, you should use a tool like this because it's good for the investors. It's good for the board members. If you have board members, it's good for your employees who can track everything that they own or the options that have been granted to them. So tools like that keep you really organized.
Yeah, that's an awesome plug. And like, for our listeners who are listening, I would guess that very few of our listeners are beyond that threshold. So I would say go out and get that. That sounds like it's a great gem.
Yeah. And the good thing is that, you have to go through a law firm to do that. So give me a call.
Yeah.
I love that. So one thing that I'm sure, comes up a lot is a lot of people have, I feel like, a negative connotation for reaching out to attorneys, or they've got this idea that it's just super, super expensive. And startups aren't known for having a ton of cash, right? So what advice would you give to these new founders and entrepreneurs about, either reaching out to legal or building a budget for legal? Is it as scary as everybody thinks?
Yeah, I'll tell you three things. One is the common advice that I've heard a lot in the past and a lot of people use is go sign up for free consultations with every attorney you can and get as much free advice as you can before you hire an attorney. That's one way to do it. What you'll end up with is you'll end up with 15 different people telling you 15 different ways to do it, and you'll not know which one to trust. You'll have a lot more knowledge when you make your
decision. Is it correct knowledge? We don't know.
Maybe. And all this is going to depend on your business, right? And in a free consultation, to be honest, a lot of attorneys don't get into the details of what your business is. Where are you going? What are your milestones? What does your team look like? Are you looking for investors sooner than later? Like, if they don't know that, all they're giving you is their general information anyways, and how you apply it is up to you. But that's common. People do that. There's nothing wrong with that, to get kind of a general lay of the land, right? Figure out what questions should you be asking. The other thing that I'll say is that a lot of people who've been down this path will tell you, would you rather pay $1,000 now or $1 million later, or whatever those ratios are? Wow. Fixing these problems, there's no shortage of stories where people have actually said, if I had addressed that up front, it would have cost me X. And since I didn't, I had to pay him $2.5 million because we didn't have the agreement written the right way. And that wasn't, certainly wasn't my intention, but that's how we resolved it, 5 years later.
Austin, let's go ahead and clip that little section he just said for sure. Like, honestly, would you rather pay $1,000 now or $100,000 later? And it's honestly, it's very true in a lot of aspects of a starting company, is especially development. I mean, I can go and get an app built for $5,000, but guess what? It's going to be terrible, and you're probably going to have to go back and do it again, right? And so, and I'm sure, but legal, I feel like that's such a good gem of advice. Is like, I understand we're trying to save money and we're really lean right now, but in the long run, I think it's an investment.
Yeah. And I would add a third thing onto there, and not just because we're doing it, but because I think that it's a smart way to go about it as a startup. Somebody connected me to a company that was looking for an IP paralegal. We don't do that, but I knew someone, so I put him in touch with them, and that company, who I didn't know beforehand, was very grateful. And they're like, "Oh, well, that's really nice of you. Tell me what you do." And I let them know. So what, and they're very much, I think, in the field where you guys are at, maybe a little more advanced than some of your listeners. But I said, well, what we do, we do patents and trademarks like other people, but what we really focus on is what we call integrated legal counsel. And a lot of people might call that outsourced general counsel, or, concierge legal services, whatever you want to call it. I call it integrated legal counsel because what we do is we want to be on your team. And it's a subscription model, so there's kind of a commitment, but it's a known commitment, right? And you can come in at different levels. But it's super scary to go from not having an attorney to hiring any attorney, because that's a lot of money per hour. And then you're paying per hour, and then you don't want to call them. And so when you do call them, you tell them as fast as you can what you think you want, and they try to interpret what you said because they don't have all the information. They give you a document that they think you need, but to be honest, a lot of times nobody knows for sure, right? And people who say they do either are lying to you, or they're charging you enough money that they've actually spent the time to figure it out, which is more than most of you guys want to spend anyways.
Yeah.
So what we do is we say, hey, there's a subscription model, bring us on board. And we actually have 2 or 3 attorneys that would kind of come on as a team. And we're like, we're your legal team. And you pay a subscription and we come in. We have some people who pay us $250 a month just to be there, so that we can build a relationship. When they call us with questions, we have not just answers, but we have answers that match their business, all the way up to thousands a month for more detailed services and integration with their team. So I think it's advisable, in part because I offer it, but also because I think building that relationship is going to save a lot of money in the long run, and a lot of heartache, and hopefully help you avoid some of those disputes that turn nasty. As businesses become valuable, people just get a little bit more self-interested sometimes.
Yeah. So kind of for the last question, what do you wish that founders knew or wish they had prepared before really even coming to you? And then what overall advice would you give to them?
I love this question. The answer might come out of left field though, because
Those are the best answers.
I don't think a lot of people are doing it.
Yeah.
And so, I call my firm Intellectual Strategies for a reason. One, because I do intellectual property and I try to be strategic around it. But two, more broadly, I think that businesses and clients that I work with need to understand their own strategy, not their IP strategy necessarily. They need to understand their business strategy. And if they do, they can create a framework, what I call a strategy framework, a clear vision, communicate that with their team. Everybody on their team knows what their business model is that they're going after. They know what their leadership position in the industry is. They understand how well the technology is being adopted into their, into the industry or the market segments they're going for. And they understand how to build the milestones off of those and KPIs, monthly or quarterly, whatever it is, right? And so having that framework unifies them as a team. When you come and say, I want a patent, I can get you 15 different types of patents. And 14 of those might not be worth anything to you in the long run, right? And this is why I don't work with large corporations anymore, because large corporations, nothing wrong with it, but they say, hey, get us patents. And then they kind of drop that on you and you go get them patent. I've had when I was younger, had a lot of partners tell me, well, they just need a patent. I'm like, well, what about this? And well, how does it fit here? No, they just need a patent. It kind of doesn't matter what it looks like in the end. So
they just need to say they have a patent.
Yeah. And quite literally that works. That is a legitimate strategy for a few really, really large companies, right?